place. We've also determined the level of outages that we're currently experiencing. Of course, it doesn't mean that we don't have a problem. The outages continue, so you still experience load shedding, and therefore you need to deal with load shedding. But we've determined that, in fact, the mitigation measures currently in place are able to mitigate and continuously reduce the levels of load shedding as we're experiencing. So I'm making the point that it is on the basis of a continuous review of the measures taken to determine whether you require a state of disaster to be declared to be able to execute the responsibilities either of the Minister of COGTA, the Minister of Electricity, or any other minister that would have been impacted by this declaration of the state of disaster. And in this regard, I'm talking about ministers that would be responsible for the commercial and financial issues, whether they would require extraordinary measures. And the determination was that, we're not at a stage where, in fact, we do require to continue the state of disaster. Do we consider it in the context of litigation? Of course, you look at litigation and you ask yourself, if we don't need a state of disaster, do we need to be in court? If you don't need the state of disaster, you don't then go and brief senior counsel to say, take me to court just so that we can be in court. It doesn't make sense. You arrive at a determination that, well, on the basis of the current review, we do not need them, so we don't need to be in court. So the point of the court technically becomes moot if you think about it, because you don't need to be having a state of disaster. And that really would have been the considerations. We factored in a whole range of considerations in arriving at this determination. And this determination has been on the basis of consultations both within COGTA, with the National Disaster Management Center, but also with other departments in government. Thank you.